Crashes involving commercial vehicles like delivery vans or company trucks can be very different from typical accidents. Attorney Tom Sinas is here to explain why that is in today's Know the Law. Good morning, Tom.
Good morning. Thank you for having me back.
Absolutely. So let's talk about how a crash with a commercial vehicle is different than your typical car accident.
Great place to start, because obviously at first blush you might think, well, it's just the bigger version of a car, so it must just be a bigger version of a car accident. And that's not accurate. Why? Well, really, we have an entirely different set of rules that apply to commercial motor vehicles as compared to regular vehicles. Of course, commercial motor vehicles are required to follow the rules of the road that all of us are required to follow, but commercial motor vehicles are also subject to things like this: an entire book of federal regulations and an entire federal agency that is responsible for overseeing really all aspects of the transportation cycle. In addition, of course, drivers of commercial motor vehicles are required to have a commercial driver's license. And so the licensure requirements, the things that you're required to know, the things that are key to operating a commercial motor vehicle that are different from a car, are also completely different. So I think the easiest place to start when you're thinking about a case like this is to think this is not a typical car crash.
Yeah, absolutely. They're held to a different standard than just your regular everyday driver. But then who can be held responsible in case of a commercial vehicle accident?
Great question. And it's really an extension of where we started, which is that commercial motor vehicle cases are inherently more complex. They have more complex rules, and they have a whole nother layer of complexity as to who can be held responsible. So the most obvious place to start, what I suppose would be similar to where you would start in a car crash, and that is, of course, the driver. But many car crash cases start and end with the responsibility of the driver. Very often, the driver is the owner of the vehicle, and that's sort of the end of it. But in a commercial motor vehicle case, it's really just the beginning. In our legal system, we have a concept known as vicarious liability, and that's just a term that means when someone else is responsible for the actions of another individual. So the most common example, of course, is an employer-employee relationship. Employers are responsible for the actions of the employee, so long as the employee is operating in the course of their employment. So in commercial motor vehicle cases, there is this question of who is the employer and who is the employee. And that may seem obvious, but it isn't always obvious. In many commercial transportation operations, the company on the other side will say, this driver was actually not my employee. This driver was an independent contractor and actually was associated with a different entity. So just getting to the question of who is vicariously responsible for the driver can be a complicated inquiry. And then there are entities that may have their own independent negligence separate and apart from this concept of vicarious liability. So oftentimes the commercial motor carrier, subject to these kind of rules, may have their own independent liability. Matter of fact, just recently, the United States Supreme Court held that a broker who's brokering a load with a motor carrier, that broker could also have liability. And these are just some of many examples that prove the bigger point that when you have this complex transportation cycle, people involved in different parts of the transportation cycle, if that cycle ends in a tragedy, there very well may be a whole array of entities that are responsible that are not obvious at first blush.
Yeah, absolutely. I mean, that's several different people, businesses, things like that. Why is it so important for people injured in a crash like this to understand all of the potentially responsible parties? Because, as you said, there could be several.
Great question. It's not just a hypothetical exercise. The answer really comes down to available insurance coverage. When you have different insurance companies, you typically have different underlying entities, meaning each entity may very well have a different insurance company or different policy that applies to that particular entity in that particular circumstance. So when you have an array of potential defendants, as we call them, you almost always have a different array of insurance policies at play. And that is really significant to the victim, because the victim may be told by, say, one entity, well, we only have a limited amount of insurance. But if in fact there are other entities that are responsible for what ultimately occurred, then that may give the victim access to more resources. And nowadays in Michigan, where we have a number of victims who no longer have unlimited no-fault medical coverage, this whole question of exposure to different insurance companies becomes even all the more important. So when you're dealing with a serious injury case involving a commercial motor vehicle, the inquiry starts with the driver, but it goes all the way through because this is ultimately the exercise that needs to be undertaken.
Yeah, sounds like a lot of work for someone, especially if they're injured in a car crash. So if that happens, what should they do next?
Well, they're certainly free to contact us. We provide, of course, a free consultation. They can find us online at sinusdramis.com. They can shoot us an email at info@sinusdramis, or then give us a call in West Michigan at 616-301-3333.
Tom, thank you so much for all that information.
Thanks again for having me.